It's a little bit after 7, and we have many of the attendees uh, who've already signed on. I'm sure a few people will continue to join us. But we'd like to get started this evening with, and I'd like to welcome everyone to the League of Women Voters of Massachusetts 100th anniversary webinar. We're doing these webinars because we can't get together in person as much as we would love to. And this is a good way for us to continue to celebrate, commemorate, and understand not only the fight for the women's right to vote, but also additional and continued work that is going on in terms of obtaining full equal rights for all Americans. So this evening, we have joining us is Barbara Berenson. And Barbara is a historian, a teacher, and an author. Many of us in the state league and local leagues were introduced to her a few years ago as she gave us background and remarks based on her book that is about Massachusetts and the women's suffrage movement, revolutionary reformers. So we've heard her talk before, and we're so pleased that she's joining again us tonight. This time, the focus is on after the 19th Amendment was passed and the campaign for the Equal Rights Amendment starting in 1920 to 100 years later, 2020, where we still do not have an Equal Rights Amendment in our US Constitution. So it'll be interesting to hear her perspective on it. She will provide remarks for about 40 minutes, and then we'll open it up to questions from everybody. We'll take questions through the chat box. So at the bottom of your screen, there is a little chat with a little bubble by it. That's where you should type in your questions, and then we'll sort through those and ask as many of those as we can. And you can type them in anytime you want. So if you have a question in the middle of her presentation, please feel free to type it in then. I'd also like to remind everyone that we are recording this webinar. So if you want to look at it again, or if you have some friends who were not able to join us, they can watch it. We'll have it posted on our League of Women Voters of Massachusetts website. And with that, I think it is time. I would like to turn it over to Barbara Berenson. So welcome, Barbara.
Thank you so much for that introduction. Thank you all for joining tonight. It is lovely to be with you, even virtually. And thank you for inviting me into your homes. So this talk tonight, which is going to focus, as you heard, on the Equal Rights Amendment, is an outgrowth of work I have been doing since I completed my book about the women's suffrage movement that Judy just mentioned a couple of years ago. And what we're going to do tonight, very quickly, in about 40 minutes, is pick up the story after 1920, talk about the last 100 years of women's progress through the Equal Rights Amendment as an organizing principle, which means we'll focus particularly on the 1920s, the 60s and 70s, and where we are today. And at the outset, most of my slides will have pictures, not so many words, but I do want to begin by noting that the United States is virtually the only major industrial democracy today that continues to lack the guarantee in its written constitution that men and women are equal under the law. And just as a reminder of what the language of the proposed Equal Rights Amendment is, and of course it states, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So now I'm going to turn to the history. I hope many of you, maybe probably a lot of you, have watched or are watching This Is America, which of course also will give you some interesting background and perspectives on the story in the 1970s in particular. So we're going to pick up our story in 1920, right after the successful, wonderful ratification of the 19th Amendment. And the two figures you see on the slide here, on the left-hand side is Maud Wood Park, who was the lead lobbyist in Washington, D.C. for the National American Women's Suffrage Association. After 1920, she becomes the first national president of the League of Women Voters. On the right is Alice Paul, who was the militant head of the National Women's Party. That was the smaller organization that was very active in picketing in front of the White House, had a very different strategy from, in general, the education, persuasion, lobbying strategy of the National American Women's Suffrage Association. During the final years of the suffrage campaign, there was quite a lot of animosity between the National American Women's Suffrage Association and the National Woman's Party. And that continued in the 1920s. This was not a schism that went away. And the reason it didn't go away has to do with the Equal Rights Amendment. So just to set the stage, at the same time as women were working so hard to gain the right to vote, they were also working very hard in support of what was called protective legislation. And that was legislation to try to protect women in the workplace by doing things like limiting the number of hours they were required to work and requiring a minimum wage. And laws that did that were challenged repeatedly in court because the very conservative Supreme Court at that time struck down those sorts of laws as applied to men under the grounds they violated the liberty of contract, the rights of employees and employers to enter into contracts freely. They disregarded the fact, of course, that employers had all the power. So how was it then that one could defend laws pertaining to women? And women didn't have labor unions. They did have labor unions, but they weren't as strong as male labor unions to look out for them and to protect their interests in the workplace. And in a famous case in 1908, attorney Louis Brandeis, who later, of course, becomes a justice of the United States Supreme Court, defended an Oregon law limiting women to working a 10-hour day. He was successful. And the reason for the success is because he persuaded the Supreme Court to focus on the differences between men and women. And the court said, as healthy mothers are essential to vigorous offspring, the physical well-being of a woman becomes an object of public interest and care in order to preserve the strength and vigor of the race. So once we had the success in Muller versus Oregon in 1908, continuing to pursue protective legislation was a high priority for many women and women's organizations, including the League of Women Voters. It was not, however, a priority for the National Woman's Party. The National Woman's Party didn't want protective legislation. They said the protective laws are a roadblock to equality. They wanted complete equality of treatment. Now, the women in the National Woman's Party were largely white, middle class or wealthy, educated, and many of them had professional jobs. They did things like work in offices. And in response to the claims of the National Woman's Party, Maud Wood Park and her allies said that an equal rights amendment is too sweeping. And some leaders in securing protective legislation included Florence Kelley in New York and Rose Schneiderman, who was very active in organizing women into labor unions. And I will just read to you a quote about what Rose Schneiderman had to say about the Equal Rights Amendment. She said, "I dare say that if Alice Paul and her allies had to sort dirty linen instead of sitting in a nice airy office, and if she then had to go home and get her own dinner, wash and mend clothes, and had 2 or 3 children to take care of, she would be ready to be protected by legislation." The League of Women Voters, the anti-ERA view, prevailed in the 1920s, but there were some other very important things that went on that I want to touch upon. So the League of Women Voters supported protective legislation. It supported new laws for aid for mothers and children, and it supported a child labor amendment. So in their early foray into politics, the focus was primarily on laws that would directly benefit women in their role as mothers and caretakers of families and children. So for example, the League of Women Voters was a leader in lobbying for and advocating for the 1921 Shepard-Towner Act, which was a law to address resources to the health of pregnant women and their newborn babies. And the statistics back then were horrifying. 20% of children died within the first year of life, 1/3 of children within the first 5 years. And this law was lobbied for by a group of women who formed into an organization called the Women's Joint Congressional Committee, which included, besides the League of Women Voters, the Women's Trade Union League, the National Consumers League, the General Federation of Women's Clubs, and others. And the law was passed in 1921. On the heels of that success, the League of Women Voters and its allies pursued a child labor amendment to ban child labor. This was a proposed constitutional amendment, and it was successfully proposed by Congress and sent out to the states to be ratified in 1924. However, there were many opponents to these efforts, and the opposition included conservative women, the same women who had opposed suffrage. And if you can see on this slide underneath this new publication, The Woman Patriot, it says, dedicated to the defense of womanhood, motherhood, the family, and the state against suffragism, feminism, and socialism. Other opponents included the American Medical Association, who viewed these laws, the Shepherd-Towner Act, as interfering with their freedom, the Catholic Church, which opposed any efforts at what it saw as possible family planning, states' rights advocates who believed the federal government should not take a role in these issues. So how, in light of the strong opposition, did these laws come to be? The answer is that there was an expectation, or another way to put it, a fear that there would be a women's bloc, that after women were enfranchised, they would vote as a bloc, and politicians were fearful of angering prospective women voters. However, it turned out that a women's bloc did not materialize in the early elections in the 1920s. And the result was the Shepherd-Towner Act was allowed to dwindle. It wasn't refunded by the end of the decade. And the Child Labor Act failed to become ratified and become a part of the state constitution. So the 1920s ends on a little bit of a dark note because some of the early successes of women were lost, but many positive things had happened. Women had fully entered the political realm. Obviously, they were still way behind as compared to men in terms of electoral success and so forth. But they had proved their clout, their organizing abilities, their lobbying ability, and that will continue to pay dividends going forward. So before I turn to the 1960s and 1970s, I'm just going to stop at a few milestones along the way. And of course, during the questions and answer, I'm happy to talk about some of these milestones or other things during these years between the end of the 1920s and the 1960s. So very importantly for the future of the Equal Rights Amendment, the Fair Labor Standards Act was signed by President Franklin Roosevelt in 1938, a major piece of New Deal legislation. And the Fair Labor Standards Act outlawed child labor, and it required pay for overtime, and it established maximum hours and so forth. And that was very important because what that law basically did was apply protective legislation across the board to men as well as women, so that ERA proponents no longer had to fear so much that they would lose out on protective legislation if the ERA were supported. So this becomes important for the story in the 1960s. In addition, of course, World War II, like every war in American history, has benefited women in terms of social change because women take on new roles, enter the workplace in great numbers during wars. And of course, World War II, here's Rosie the Riveter, was no exception to that pattern. The birth control pill, there had been earlier contraceptives available, although sometimes illegally available during during earlier decades of the 20th century. But the ready availability of the birth control pill, although of course it required a medical prescription, finally gave women some control over family planning. The civil rights movement, this picture here is of Rosa Parks, but of course the civil rights movement, which really got underway in the 1950s, was also very important to what would become the second wave of feminism, because just as the women's rights movement in the 19th century grew directly out of the abolitionism or anti-slavery movement, so too the women's rights movement of the 60s and 70s would borrow many of the tactics, strategies, and even participants from the civil rights movement. 1960, after John Kennedy is elected president of the United States, at the urging of Eleanor Roosevelt and a number of other women leaders, he's persuaded to appoint a very significant commission on the status of women. Another important participant on that commission was Polly Murray, We'll talk more about her in a couple of minutes, but Polly Murray was one of the early architects of the theory that perhaps one could legally use the Equal Protection Clause of the 14th Amendment, which of course had been used to ban racial discrimination against sex discrimination as well. In 1963, the Equal Pay Act is passed. That was an enormous success, mandating equal pay for men and women in the same jobs. It was, of course, a limited success in the sense that it required equal pay for equal jobs. And one of the issues was that women had unequal jobs. So it was certainly not a final victory, but nonetheless, it was a very important legislative achievement and accomplishment. 1963 is also the same year that Betty Friedan arrives on the national scene when she publishes her book, The Feminine Mystique, when she described the problem that has no name. Taking the perspective of a white, middle-class, educated person, she talked about how women had become enslaved to their appliances, their husbands, and their children. And Betty Friedan, of course, this book revolutionized many people, and she would become a leader shortly in the new women's rights movement. The Civil Rights Act of 1964 is passed. Title VII, which prohibits discrimination in employment on the basis of race, color, religion, national origin, also included sex. So a very important tool to try to ban sex discrimination in the employment realm. This law, however, was not initially enforced by the Equal Employment Opportunity Commission. The EEOC chose to focus on complaints brought about racial discrimination and ignore complaints brought about sex discrimination. This is Lyndon Johnson in the slide, signing that legislation. And in response to the passage of Title VII and the failure of the EEOC to enforce it, Betty Friedan and Polly Murray and several other leading women advocates for change came together in 1966 and formed a new organization, NOW, standing for the National Organization for Women. And I just want to point out one thing about the name, and that is, very significantly, it was not called the National Organization of Women, the National Organization for Women, because very critically, women recognized, as the suffragists had, that male allies would be essential to success. Now's statement of purpose called for equal partnership of the sexes, and they rejected the old-fashioned assumption that a man had to carry the sole burden of supporting his wife and family, and that a woman was entitled to lifelong support upon marriage, and rejected the assumption that marriage, home, and family are a woman's world. Now came up with, a couple of years later, an extensive Bill of Rights, which included, of course, as item number 1, an equal rights constitutional amendment. So the full-fledged revival of the Equal Rights Amendment from the 1920s. The ERA in these intervening years had never fully gone away. Alice Paul, who continued to live until 1977, every year would trek over to Capitol Hill and seek to get new attention to the Equal Rights Amendment. The Democratic and Republican Party had begun to pay attention to it, but it wasn't until NOW issued its Bill of Rights with the ERA front and center that it became a major new cause of the second wave of feminism. You can see the other list here of priorities, some of things of which have been accomplished, and many of which here we are in 2020 still fighting for. Very importantly, one of the things that NOW did was tell women that these issues were not their sole individual problem, that they were societal issues, that society had to help address these things. It wasn't up to each individual woman to try only to address them as best she could. 1968, of course, is a very pivotal year for many reasons, and as we're looking at the TVs and reading the news or attending protests these days, many people are, of course, drawing comparisons in different ways to 1968. One of the things that happened in 1968 is there was high-profile protests by younger women who really are in many ways analogous to the National Women's Party, challenging cultural norms and bringing new changes to their demands. So this was a famous protest outside the Miss America pageant at Atlantic City, New Jersey, where, by the way, bras were not burned, despite the fact that some conservative commentators claimed that they were. In 1969, Shirley Chisholm, who had been elected to Congress in 1968, gives a speech about the Equal Rights Amendment in the House of Representatives. And she says that she wishes to introduce this proposal. And she says that women don't need extra protection, that everybody needs the same protection. Laws to protect working people and guarantee them fair pay, safe working conditions, and so forth. In 1970, on August 26, which is, of course, the 50th anniversary of the ratification of the 19th Amendment, which gave women the vote, Betty Friedan had called for a women's strike for equality, which was observed in cities all across the country. And the demands were many. You can see them on this slide, but front and center, a demand for the Equal Rights Amendment, but also demands for the right to abortion, right to childcare, equal opportunity, as well as opposition to the Vietnam War, racial discrimination, and support of gay rights. So August 26, 1970, which of course, every time I think of that date, I think about August 26, 2020, and what should be done on that day. Gloria Steinem, who has emerged as yet another very important leader in the women's rights movement, begins publishing her magazine, Ms. Magazine, and many of you probably are familiar with this initial cover showing Wonder Woman on the cover, Wonder Woman for President. Showing how much change had percolated down to mainstream culture, the fall of 1970 is when the Mary Tyler Moore Show first becomes on the air. And looking back, I'm sure if you have children or grandchildren, they may find it hopelessly old-fashioned, but it was revolutionary when it began, of course, showing Mary Richards living independently without a man and having a job in a city. In 1972, Congress passed the Equal Rights Amendment and sent it out to the states to be ratified. The photograph here is of Martha Griffiths, a congresswoman from Michigan, who was instrumental in the legislative success of the Equal Rights Amendment. But you can see how popular it was. The women's movement seemed an unstoppable force at that point. Everybody, it seemed, was in favor of the Equal Rights Amendment, both political parties. The House approved it by overwhelming majorities, 354 to 23. The Senate, 84 to 8. And in that first year, 1972, 22 states ratified the Equal Rights Amendment, including the state of Massachusetts. This was an intersectional movement, to use a modern word. It included support for rights of minorities and rights for gays. So things were looking very good, very happy during 1972. But of course, a backlash was brewing. The backlash included many different participants, but nobody is more responsible for organizing the backlash by woman against woman than Phyllis Schlafly. And she organized a group called Stop ERA, and the STOP was an acronym that stood for Stop Taking Our Privileges. And that was what they believed, that the Equal Rights Amendment would take away the privileges of being supported by a man, the right to be, as she said, a housewife, the right to be a mother, that these were evil libers, evil feminists wanting to take away privileges. And so she portrayed feminism as an attack on women rather than as a defense of women. And that the ERA, she claimed, was an assault on the role of woman as a wife and mother and on the family as a basic unit of society. Who were her followers? They were conservatives of all stripes, but they were largely full-time homemakers, regular churchgoers, some Catholic, but particularly evangelical Protestants. This is this cartoon from the suffrage era, but it makes me think of Phyllis Schlafly, so I decided to use it. This cartoon shows a woman as she ascends the steps beyond suffrage that after suffrage, she confronts only strife, anxiety, and loneliness, and is left behind home, children, marriage, and love. This is Ruth Bader Ginsburg speaking in 1971, saying, "The pedestal upon which women have been placed has all too often been revealed as a cage, not a pedestal," which makes me think of another favorite suffrage cartoon, when the suffragists mocked the woman on the left, the woman on a pedestal, as somebody who was ignorant and who didn't realize that her pedestal was in fact akin to a cage. So ERA ratification, as I said, starts off fast in 1972. 1973 ratification continues at a reasonable pace. 8 more states ratify it. And then, of course, we have Roe versus Wade, decided by the United States Supreme Court in 1973, that upheld a woman's right to an abortion. And there was then a joining of 2 issues. A joining of a desire to overturn Roe versus Wade, along with the desire to stop the Equal Rights Amendment. There was also a joining of the issues on the other side. So the Equal Rights Amendment and the pro-choice movement became joined. ERA ratification slows essentially to a crawl. As you can see, not only did a very few states include ratifying it or continue to ratify it later in the 1970s, but also 5 states that had previously ratified it voted to undo their ratification. It's a complicated legal issue as to whether that's allowed, and it probably isn't, but they nonetheless tried to do so, indicating the strength of the backlash. 1977, on August 26th, again, that anniversary day, there was a huge Equal Rights Amendment march, which is also an Alice Paul Memorial March because she had died. 1977, in November, at a conference for women, and you can see in a former era, 3 first ladies all together, Lady Bird Johnson, Rosalind Carter, and Betty Ford. Bella Abzug is on the right. And the Equal Rights Amendment was extended by Congress for 3 years. There had initially been a deadline in the legislation proposing the Equal Rights Amendment, not in the text of the law itself, but in the legislation. And the deadline was extended by 3 years to 1982. But at the same time as that conference was going on, there was a counter-conference and protest against the Equal Rights Amendment, also in Houston. No further states ratified the Equal Rights Amendment. It remained at 35 states. And in 1980, when Ronald Reagan becomes the Republican nominee for president, the Republican Party drops its support for the Equal Rights Amendment. And this was, of course, the era of Jerry Falwell, the moral majority, and Phyllis Schlafly remains front and center. Ronald Reagan is elected. A new conservative era begins. But meanwhile, and I'll just touch on this very briefly, in the courts, there is a lot of activity. Many women's rights are protected in the courts during the 1970s, 1980s, 1990s, largely by these 2 women, Ruth Bader Ginsburg, first as an attorney for women's rights through the ACLU, and Sandra Day O'Connor, the first woman to serve on the United States Supreme Court. They, picking up what Dorothy Kenyon, Polly Murray, and others had argued, they inferred sex equality, as I said earlier, from the Equal Protection Clause of the 14th Amendment. And using that approach, they persuaded courts to strike down many discriminatory laws as violative of the Equal Protection Clause. But they used a standard, and I'm sure there are some lawyers watching tonight, called intermediate scrutiny, which was not the strict scrutiny that is applied to race-based laws. So it was very helpful, but not enough. There's another picture of Ruth Bader Ginsburg and Sandra Day O'Connor together. So after 1980, the Reagan Revolution, his election, obviously things continued, but the Equal Rights Amendment, to a very large degree, drops by the wayside. And between 1980 and 2015, not that many people talked about the Equal Rights Amendment that often. It's not that it was gone for good necessarily, but it was not a major focus. A major focus was getting women elected to office, making change through the courts, and making change through the political system. So just some of the milestones, again, just to review, but of course these are fresher in all of our memories. We have the first candidate for vice president, Geraldine Ferraro, a woman, in 1984. That's Anita Hill, testifying in 1991. Nancy Pelosi, the first time she became Speaker of the House in 2007. Hillary Clinton, of course, the first woman nominated for president by a major political party, 2016. After the election of Trump, we had a new wave, a new energy in women's rights. And of course, this is a scene from the Women's March in January 2017. The Me Too movement begins really as an outgrowth of the Women's March and high-profile cases of sexual harassment and sexual abuse. A wave of new women elected to Congress. Here at the State of the Union address, many of them, of course, are wearing so-called suffrage white. But it's not as if, of course, all women were on the same page, just as Phyllis Schlafly and her allies were not on the same page as the woman who advocated for the Equal Rights Amendment. So women are once again, and have always been, a group divided. In fact, when you look, and I'm sure many of you know these statistics well, at the 2016 election, it turns out that while Clinton won 54% of women's vote, she was that high because non-white women voted for her in overwhelming numbers, 82%. But white women, depending on which poll you look at, either 47% or slightly over 50% of white women supported Donald Trump in 2016. So now I'm going to jump to where we are today, when there is a new focus on the Equal Rights Amendment, as I hope all of you know. Why that is directly responsive to the current president. The appointments of Brett Kavanaugh and Neil Gorsuch to the United States Supreme Court have shifted the balance on the court. So the court now has 5 firm conservative votes. And need I say more about Ruth Bader Ginsburg than Saturday Night Live said a couple of years ago? So there is already a 5-4 conservative majority, and grave fear that the balance could shift even more. The Equal Rights Amendment in the last several years has been ratified by an additional 3 states. So 38 states have now ratified the Equal Rights Amendment. Nevada in 2017, Illinois in 2018, and Virginia in 2020. And I know some people think it's almost like a lark or a frolic that states have done so, but they actually did so as part of a concerted strategy, because the archivist, David Ferrero, wrote in response to a request from Congresswoman Carolyn Maloney of New York in 2012, a letter saying essentially that yes, we have 35 states that have ratified the Equal Rights Amendment, and if 3 more ratify it, then I, as the archivist, announce that the Equal Rights Amendment is part of the United States Constitution. So 3 more states have now ratified the Equal Rights Amendment, bringing the total to 38. There are, of course, those 5 states who claim that they have rescinded it. One of the remaining issues, or one of the objections to the Equal Rights Amendment, mentioned by many conservatives, of course, is that it would force women to sign up for the draft. So I also want to call your attention to something that happened very recently, but the news was kind of lost in the midst of the pandemic and other news, and that is that a national commission appointed to investigate military, national, and public service has recommended that the Selective Service Act be modified to include women, and that women as well as men would have to register for the Selective Service Act, thereby making them eligible for any future potential draft. So where are we now? Where we are is that despite the fact that these 3 additional states have ratified the Equal Rights Amendment, President Trump's Office of Legal Counsel told the archivist not to enter the Equal Rights Amendment into the Constitution, claiming that the Equal Rights Amendment had expired because of the 1982 deadline. This letter was written in January of 2020. The House of Representatives has passed a resolution removing the deadline. They did that in February, but there has been no action in the Senate, and there certainly won't be any action in the Senate before the next election. What is going on right now is that there were three, but now there are two lawsuits have been filed asking courts to rule on whether or not the Equal Rights Amendment is now part of the Constitution. And the issues in the lawsuits are primarily on the validity of the deadline. In other words, if the 1982 deadline is legitimate and cannot be changed by a subsequent Congress, then the Equal Rights Amendment loses. If, however, Congress could change the legislative deadline and the Senate does so at a future point in time, perhaps the Equal Rights Amendment could be adopted. And then there is also an argument made by some that no deadline can ever bind the amendment process, which gives states certain responsibilities and does not condition those responsibilities on the existence of a deadline. So basically, the bottom line is that we need to stay tuned. The 2020 election is obviously a critical election in this country for many different reasons, and the Equal Rights Amendment is one of the issues on that long list of reasons why it's so important to get out and vote. And the League of Women Voters, of course, does so much to support voter education, voter advocacy, access to the ballot, and so forth. So thank you very much to the League. And with that, I'm going to stop because I really wanted to make sure that I left plenty of time for your questions and your comments.
Well, thank you so much, Barbara. I know I learned a lot, so we really appreciate all that. So I'm going to start off. I'm the person that's been elected to ask the questions. So I'm going to start with one that came in just a minute ago. So the question is, what role did the U.S. Supreme Court decisions in the 70s and 80s giving rights to women, how did that, in your perspective, how did that impact sort of the slowing down of the ERA, the passage of the ERA?
So, you know, it like so many things in American history, you know, things have a positive and a negative consequence. So the positive consequence of all these legal changes is how much women have benefited. And many women, I assume, attending this discussion tonight have directly benefited from all the legal changes over these last years. The fact that the Equal Protection Clause has been read so broadly, and the fact that many more laws have been passed as well, like laws protecting women's rights in pregnancy and other things. So those advances have been huge. The downside in terms of an Equal Rights Amendment is when there were so many successes in the courts, the Equal Rights Amendment, I believe, seemed to many to be less necessary, less essential, and that diminished some of the momentum for it. And people somehow didn't seem to anticipate that the courts can give and the courts can take away. And so it really wasn't until the Supreme Court lost Sandra Day O'Connor, this new conservative court, so many new conservative judges appointed to the lower courts, really made people sort of stand up and say, my goodness, you know, these rights that we have could leave us.
Yeah, yeah. Another question. What is your perspective on younger women? How do they view the need for the ERA? I have a 24-year-old daughter, and I know that it's, you know, she finds it, I'm going to make her watch this because she finds it hard to believe, you know, that all this went on. So I'm not even sure she really knows what the ERA is.
Well, I think that like so many things, there's, you know, a general failure in our society to impress upon people the importance of history. And so a lot of young women know very little about the Equal Rights Amendment. The same polls that show how few Americans can name the 3 branches of government, if they continue and ask the question, might get answers suggesting that many people believe that there is already an Equal Rights Amendment in the Constitution. Certainly polls suggest that when people are asked, would you support equal rights for women in the Constitution, overwhelming majorities say yes. but then it's attacked as being a right to abortion on demand and various other things, and then opposition begins. I think that, I think it's wonderful on the one hand that younger women feel confident enough about their place in society that they feel that they might not have to be concerned. I think all of us who are a little bit older want them to realize how vulnerable we all are, how quickly backlash can form, and that the United States really does, stand out there by not having a constitutional provision that mentions women and gives them equal rights. I mean, in that sense, Alice Paul was right. She was ahead of her times in the 1920s, but she certainly was right that after the 19th Amendment granting women the right to vote, the next logical thing would be an amendment granting women equal rights.
Yeah. Next question is, you mentioned Mrs. America. The question is, how accurate is it, that series?
That's a great question. And, the answer is that it's accurate in many ways and inaccurate in others. Every episode, of course, comes with a disclaimer saying that, some scenes are invented, some dialogues are invented, some characters are invented. So Alice, for instance, Phyllis Schlafly's early sidekick, is an invented character. There was no Alice in reality. So many scenes are invented, but many things are very accurate. I mean, it certainly portrays what Phyllis Schlafly did and where she came from and her conservatism and the marrying of issues like abortion and her reaching out to the evangelical movement and so forth very accurately, I think. I think it does a less good job in discussing the pro-ERA leaders. I love that it gives attention to Gloria Steinem, Bella Agza, Shirley Chisholm, and so forth. But I wish each of them deserves her own series. And I personally felt that Betty Friedan, this notion that she was difficult, I think becomes a focal point in Mrs. America that I think does a disservice to her remarkable importance and legacy.
Mm-hmm. Yeah.
I don't know if people have follow-up specific questions, please type them into the chat.
Yeah. And this is a question I asked you yesterday. Someone wrote, can you explain your pronunciation of women singular versus women plural? So someone else was thinking about that too.
So yes, and I said to Patty in my suffrage talks, I often try to tell people, sometimes I forget, that I refer to the woman singular suffrage movement because that's what the participants themselves called it. It is completely fine to call it the women's suffrage movement or the women suffrage movement, but I chose to use the terminology that they used. Certainly when I'm talking about women's rights and the Equal Rights Amendment, I am using woman plural. And if at any point it sounded as if I wasn't, it may simply be that I have uttered the term woman more times than I can possibly count as I've spoken about suffrage so many times over these last couple of years. But that's the only reason.
Yeah. All right. Next question. The question is if, and then in parentheses, when, exclamation mark, the ERA becomes part of the Constitution, will there be any difference in how it is implemented in states that never ratified it?
So that's a very interesting question because it's really several questions in one. Because the first question is, what would the Equal Rights Amendment do? The Equal Rights Amendment bars discrimination. But the words of the Equal Rights Amendment, like the words equal protection or due process, it's not clear how a court would interpret it. We have very few provisions in the Constitution that can only be interpreted one way. You can vote if you're 18. You can't become president unless you're 35. But so I think one of the weaknesses that women have to address in proposing or in further advocating for the Equal Rights Amendment is what they think it would actually accomplish. So for instance, the issue of abortion comes in when many advocates of the Equal Rights Amendment say the ERA has nothing to do with abortion, and others say the Equal Rights Amendment has everything to do with a woman's reproductive rights. So one issue is, how would the Equal Rights Amendment be interpreted? If it is adopted, presumably it would have a national interpretation ultimately by the United States Supreme Court, and it wouldn't matter whether or not it had been ratified in a state. However, in a state like Massachusetts, which has its own state equal rights amendment as part of its constitution, we have already made so much progress when it comes to state law that the changes caused by a federal equal rights amendment presumably would be lesser than in certain other states.
Okay. This question is, would the ERA provide a legal basis to eliminate the inherent biases that are in AI software and predictive software developed by Silicon Valley?
So that's a very interesting question. And I assume by that question of AI software, so for people in the audience who might not be as familiar with it, I think what this question is referring to is artificial intelligence software that uses algorithms to make predictions about people's behavior, or if it's in the insurance industry, what a person's life is worth or job is worth, and so forth. Would the Equal Rights Amendment provide a legal basis? Probably not, at least that's my first immediate reaction, because the Equal Rights Amendment, by its words, talks about laws passed by, I'm just looking at the wording here so to make sure I read it right, equality of rights shall not be denied or abridged by the United States or by any state. So it's really looking at government action. So action by private companies really generally depends on other laws, whether they're federal laws or state laws. But creative lawyers may be able to figure out, some way to use the Equal Rights Amendment or use it to suggest that something else should be interpreted in a particular way. But I don't believe the Equal Rights Amendment itself would invalidate use of those algorithms.
Yeah. So this question, we've had this now, two people have asked this similar question, and the question is, would you mention what Scalia said about women not being protected in the Constitution? And someone else asked about that too, two people.
I believe that what people are referring to is former, now deceased Justice Scalia, who of course was very conservative, made a comment, and we could Google it to get his exact words, but essentially that the Constitution does not protect women's rights. He viewed himself as what's known as a textualist, somebody he claimed who was bound by the strict words of the Constitution. And he said that women are not mentioned in the Equal Protection Clause. The Equal Protection Clause, of course, was passed in the wake of the Civil War. It was addressed toward race issues, not gender issues. And then, as I said, creative lawyers like Polly Murray and others had this wonderful idea that it could be used to eradicate what she called Jane Crow, as well as Jim Crow laws. But Scalia disagreed with that and essentially said that there are no rights protecting women in the Constitution other than the limited right to vote in the 19th Amendment. If you're thinking of something different, you can type that in, but I think that that's generally the famous line that Scalia gave about women's rights in the Constitution.
Yeah. And this one is, do you believe the pandemic will overshadow the importance of moving the ERA forward as we approach the November 2020 election and into the next president's agenda, assuming we have a different president, or your predictions of where we will see this on the priority list for the next president?
Those are wonderful questions. I mean, when it comes to politics, I'm happy to give you my thoughts, but this is where, as a historian, I can tell you about the past and the trends that I expect, but when it comes to predicting the future, I'm no more qualified than anybody else listening in. I think that many issues overshadow the Equal Rights Amendment right now. Just speaking personally, as committed as I am to the Equal Rights Amendment and as avidly as I am following these different lawsuits and every bit of progress, right now it seems to me we are dealing with so many issues, and of course with what's going on right now, racial issues, breakdown of societal norms, the challenges to the rule of law. I mean, there are so many issues to consider that I would be surprised personally, I think, if the Equal Rights Amendment gets that much focus. It certainly would be something that any Democratic candidate, and I assume Joe Biden, supports it, and I'm sure he's on record as supporting it. I'm just not sure it's going to be front and center in terms of news coverage now. And in terms of priority list for the next president, I think that if there is a Democratic president, if there were a Democratic Senate, I think that the Senate would act to remove the deadline also. The president would order the archivist to add the Equal Rights Amendment to the Constitution, but then I do believe there would be a new court challenge, a court challenge claiming that the ERA was not in fact ratified properly because the deadline had expired and because 5 states had rescinded it. Some of you may know that Ruth Bader Ginsburg actually spoke to this issue not that long ago, and certainly not binding herself as a justice, but I think just speaking as sort of an interested bystander or observer, she recommended that ERA advocates ought to start over. So I think there are some very different opinions on what is the best way to proceed.
Yeah. And someone wants to know what organizations are managing the current ERA situation, including the lawsuits?
Oh, so that's another very good question. So there are a number of different organizations out there. I mean, NOW continues to work. The Feminist Majority is probably the largest, best known organization supporting the Equal Rights Amendment. There's an ERA coalition comprised of many different women's groups. The lawsuits that exist are brought by different groups. So one of the lawsuits, what likely or what might end up being the major lawsuit, but famous last words, I could be wrong, is a lawsuit brought by the attorney generals of the 3 states that have recently ratified, Nevada, Illinois, and Virginia, asking the archivist to make the ERA part of the Constitution. And a separate lawsuit arguing the opposite was brought by attorneys generals of 3 southern states. And they have now asked to intervene in that case. So one of the lawsuits is by states' attorneys generals. The other lawsuit is actually filed here in Massachusetts. And that's brought on behalf of a pro-ERA organization called Equal Means Equal, another organization, I believe, of middle school girls, and an individual person. And that lawsuit, the lead lawyer is Wendy Murphy, who some of you might know, who lives here in Massachusetts. And that lawsuit is arguing also that the ERA has been adopted, and they have used individual plaintiff rather than states' attorneys generals to argue. One of the things you always need in federal court, in courts, is standing. And so they have an actual plaintiff who is claiming that she herself has been harmed by lack of an Equal Rights Amendment. And which one of these 2 lawsuits of the 2 that exist, and there could be others filed, but if we leave it at these 2, will ultimately be the one that percolates through the system, we just don't know yet.
Yeah. And I think this might be the last question. I don't see any more in the chat, but the question is, did Eleanor Roosevelt ever come out in support of the ERA?
I don't believe so, but I am not certain. So Eleanor Roosevelt died before 1963. So she was around when President Kennedy's Commission on Women began, but she died before its work concluded in 1963. She may have, because the 1950s was where opposition to the ERA diminished a lot, but it hadn't yet become such a focal point as it became later. So I do not know if Eleanor Roosevelt had focused by that point on the Equal Rights Amendment, or if her focus was so much on the actual specific legislative recommendations in Kennedy's Commission on Women. It's an excellent question, and next time I give this talk, I'll make sure I get that answer. but I am just not sure. But she was, but that's, you know, she unfortunately leaves history before 1963. But
Right,
that's
right.
another very good question.
All right, this is the last one. Sorry, we did get one more.
Great, because it's not quite 8 o'clock.
Yeah, a couple more minutes. What are the basic roots of anti-women's rights in the US, given all other developed countries have provided equal rights for women?
Well, that's a very interesting question, which
Probably can't be answered in 2 minutes.
yes, you know, I think it has to do with the way the conservative movement in this country, you know, has established itself, that we have had a broader group of conservatives who have claimed that the Equal Rights Amendment harms women rather than helps them. And that has happened more successfully here than elsewhere. I think if you dig down not too far, you know, everything in this country comes down to race at some level. And so the same conservative movement that attacked the Equal Rights Amendment and has attacked abortion is also the same conservative movement that attacked movements toward racial justice and so forth. So I think it sort of is a very complicated onion that we have in the United States. And our conservative movement has been, as we all know, more successful than in certain other states. One other piece of it that I will add, which is also important, is that the United States Constitution, by the intent of the framers, is particularly hard to amend. I mean, what is necessary to amend it? The support of a supermajority of the House, a supermajority of the Senate, and ratification by state legislatures in 3/4 of the states. I mean, that is an almost insurmountable burden, which is why our Constitution, by design, has so rarely been amended. Many other constitutions, including, by the way, most state constitutions, are much easier to amend. So that's another reason. And then another very important reason is that certain other countries in the world, for obvious reasons, needed new constitutions after World War II. And when new constitutions were passed after World War II, many of them tracked language that was in the Model United Nations charters and so forth, and so adopted those rights into them. Also, just to be fair to this country, I will add, of course, that just because something is in a constitution doesn't necessarily, of course, make it so. But the United States has had in recent years, you know, a very strong, very powerful conservative movement and a constitution that is very, very difficult to amend. So those are certainly two things I would point to.
Yeah, okay. Well, Barbara, I think that's all the questions for tonight. I just wanted to thank everybody for joining us. I want to thank Barbara for all of the wealth of knowledge she has imparted upon us. I wanted to also thank Judy Zombrecker, the co-president of the League, for giving us the welcoming remarks, and Bryn Gorman and Taylor Granger, who are the LWVMA staff who helped to put this webinar together, and to everyone who joined us. Thank you so much, and keep an eye out for future webinars of this sort that hopefully we'll be offering over the next coming months, since we may all be still sheltering in place for some time.
And I just want to thank you so much for having me. It is such an honor and pleasure always to be associated with the League of Women Voters in any capacity. And so thank you very much, and stay well, everybody.
Yeah, thanks so much, Barbara. Good night, everyone.